Be ready. Start. This is an appeal by Caltus India Limited, Kochi Terminal, Ernakulam, to reverse the order of a learned single judge of this court dismissing OP number 489 of 1957. The respondents in the appeal are the Industrial Tribunal Number 2, Ernakulam, the workmen of the appellant company, represented by the President, Petroleum Workers Union, Ernakulam, and the State of Kerala, represented by the Secretary, Labour and Local Administration Department, Para. The respondent to union made a charter of demands containing 17 heads on 10 September 1955 on the appellant company, and as a consequence of this an industrial dispute arose between the workers and the management of the appellant company. There was a reference of this dispute on 31 August 1956 to the Respondent 1 Tribunal by the appropriate government, the Respondent 3 before us. The tribunal passed an award on 12 October 1957, which was duly published in the Gazette dated 5 November 1957 and became enforceable on 5 December of the same year. Several of the heads of disputes were settled between the parties, and only those heads covered by issues 6, 7, 13 and 17 remained without settlement at the time of the filing of the writ petition, out of which the present appeal arises. The applicant company filed OP number 489 of 1957 seeking to quash that portion of the award covered by the said four issues. Since the filing of the writ petition, the parties had compromised their differences further and filed an argument dated 30 January 1958 in court. The only disputes remaining further to be investigated in the writ petition being the disputed covered by issues 7 and 17. Para. On issue 7, the tribunal held that since in almost all the industrial concerns in and around Ernakulam Saturday afternoon being a holiday, in conformity with such practice obtaining in other industrial institutions, there would be no work in the appellant company also from 1 p.m. on Saturday. Coming to issue 17, the tribunal gave retrospective effect to the award from 10th October 1955, that being the date of the demand made by the union. Under this issue, the tribunal directed that the arrears in basis wages, duty and overtime allowances and allowance for Saturday afternoon work at overtime rates would be calculated from 10 October 1955. As we have already observed, the dispute before the learned single judge was only regarding the retrospective operation of the award covered by the issue 17 in relation to the point covered by issue 7. The learned judge dismissed the writ petition, holding that there was no question of want of jurisdiction. When the tribunal gave retrospective effect for issue 17, had left that question of retrospectively to the tribunal's decision. The appellant company questioned the correctness of this decision in the present appeal. There is no claim anywhere regarding payment of compensation by way of overtime allowance for the work already done on Saturdays after 1 p.m. It is also worthwhile to note that the company was well within its legal rights. Stop.